being threatened with something called a default judgment, and I have no idea what that is.
Okay. Well, Alistair, it's a good question, and unfortunately it's a common scenario. It does happen much more than it should. So when you get served with something, if you understand or believe it to be a BC Supreme Court civil claim, you have 21 days, at a minimum 21 days to file a response. It could be different times depending where you are, but let's just say it's 21 days. And you fail to do that, the other side can get what's called a default judgment. And that effectively means if you don't file a response, which you have to do a similar document, you can find that online, you have to complete it, you have to sign it, and this is without a lawyer, if you do it yourself, file it with a Supreme Court that's in your neighborhood, or generally a Supreme Court, and that means you have to go to the courthouse or use an agent, but usually as a layperson you go down there, get it stamped, then you have to file it, and so then you have to serve it on the party that sent it to you, or their lawyer. When you see the notice of civil claim, it'll have a bunch of documentation on it, but usually on the last or second last page, it'll say if the person did it themselves or the lawyer did it.
Right.
Whoever that was, that's who you've got to serve it. Okay? If you don't, and now let's say you didn't, and it's 2 months and you've got a very difficult time, you've got a default judgment. The problem with that is they can not necessarily give you notice. So the lawyer for the other side can actually attend court without you, not even tell you they're going, and get a default judgment for the whole thing. It's like you never responded, and it's like you have no counter argument. So let's say on the case you're talking about, you had a really good argument, like they said you owe them $100,000, and you're like, no, I paid you that back, and I've got the evidence of it. Which a judge might say you don't have to pay them anything. Yeah. But because you didn't respond, they got default judgment, they can get a judgment for $100,000. To undo that is a bit of a nightmare. It takes a long time, very technical. The courts they want you to respond to the rules and do what you're supposed to do on time. They don't want to have a million people ignoring or busy and not do that. It's a very difficult thing.
Even if you're going through family stuff at the time?
Well, that's quite important, and that can come up. But you have to do an application to set aside the default judgment. You have to put all that evidence into what's called an affidavit, so the judge can get it, swear an affidavit. That's another process that's very difficult on your own. Again, you have to file it. You have to put together the law of the facts and the law in an application. You have to serve the other side. So you can see very quickly that's way more work than just responding in the first instance.
Right.
And you've already got this judgments against you for $100,000 that someone could go and take and put on your property if you have property. They could, in theory, take it to your bank and get money out of your bank account. And so the basic situation is respond. But if you haven't, I really recommend you get a lawyer at that point because it is very technical. People show up and they say, "Hey, Judge, I don't know anything about anything," and I've seen this unfortunately too many times. And they say, "And I was going through very difficult times," and the judge might be, "I understand, and I'm with you on this, but not procedurally." The judge's hands are tied, and they have to have in the right format. They have to have it in sworn testimony. They have to have it in an application so the other side can respond. So if you just show up to court and say, "Hey, judge, help me out," you're going to get no satisfaction. You're going to get turned away, and the judgment's out there doing whatever they want to do with it again. So quite serious. Honestly, it's very technical, very difficult to overturn a default judgment, as a lawyer even.
Right.
You have to have good reasons. Sounds like you would have good reasons if we could do that. But it can't be, it was inconvenient. It can't be, what unfortunately, Alistair, happens a lot is people, we all do this in our own lives, unfortunately, they avoid difficult things. Don't let this be one of those things. This becomes way more difficult, way more serious. Deal with it. Get online, Google what do you do when you get a notice of civil claim, but don't let it sit.
Yeah, it makes sense.